Hello, this is Kevin Cope. I'm an associate with the litigation department in Buffalo, New York. Today on the webinar, I talked about New York State's proposed legislation that would ban non-compete agreements across New York State. Essentially, the New York State proposed legislation tracks the Federal Trade Commission's proposed regulation that bans non-compete agreements. It was introduced a few days after the FTC proposed that regulation. The proposed legislation in New York State would introduce a new section 191-D to the New York State labor law. It would ban all non-competes as of 30 days after the signing of that bill, and would preclude employers from entering into non-compete agreements with employees after that date. Violation of that statute could bring some heavy penalties to employers, including allowing a private cause of action for employees against employers that would include a $10,000 liquidated, up to $10,000 in liquidated damages, actual damages, attorney's fees, and costs in instituting the litigation. The issue with this proposed legislation, just like the FTC's proposed regulation, is how broadly non-competes are construed. It is essentially anything that would preclude an employee from securing gainful employment. So that would bring into question whether or not non-solicitation agreements, non-disclosure agreements, and other protective measures employers enter into with employees would be included within the definition of a non-compete agreement. So it's important that employers look towards their non-compete agreements to ensure that, one, they are only entering into non-compete agreements with employees that are necessary to protect from when they would leave employment. You don't want to enter into non-competing agreements with employees that you have no intention of ever enforcing that agreement. And two, you want to ensure that all of your anti-competitive agreements are as narrowly tailored as possible. You want your non-compete agreements to be as narrowly tailored in both geography and in time, as well as your non-solicitation agreements to be narrowly tailored to customers that employee would have access to during their employment, as well as non-disclosure agreements to be narrowly tailored to the types of information that employee would have access to during their employment. That way, employers run less of a risk of having those types of agreements to be included within the definition of non-compete agreements should the New York legislature pass the proposed legislation, or if the FTC implements a national ban on non-compete agreements. On the webinar, we also heard from Kate McClung on wage and hour dues and don'ts. We heard from Emily Fallon on developing dynamics concerning housing asylees in New York State. And we heard from Mark Doradov on two cases in the Supreme Court relating to copyright and patent cases. We at Schoeneck King are here keeping tabs on these developments and can provide you with the assistance you need should you need our help. Thank you.